we were talking about confidentiality and some of the exceptions to confidentiality, but the families do have an expectation of privacy, and so parenting coordinators are required to keep detailed records of sessions and interventions, any reports that you prepare. That has a different set of confidentiality guidelines. And certainly I do a lot of educational training, and I often use examples of real families that I've worked with, and I have to disguise, change so that their privacy is protected. So, the scope of authority is another guideline that is new and has been revised. This is one of the most controversial issues being discussed currently. The scope of authority refers to the parenting coordinator's ability to make substantive decisions for families when they can't or won't make a decision. In some areas, the courts have said, no, this is for the judge. In other areas, the courts have said, yes, you make the decision. We don't want these families back in our court because the matters that are coming before the court are not matters of law. They're matters of family management. Should the child play soccer, or should the child dance, or should the child do music, or should the child do art? These are not matters of law. These are family management issues that are there. And so that's why the courts have made different decisions about this. And so as you are contemplating your legislation, your scheme, this will be another area, as it has been for all countries developing this program, to figure out what's the ideal scope of authority for parenting coordinators. If you are authorized to make decisions, this should be in the order, the court's order, so that it's very clear what you're authorized to do, what you're not authorized to do, so that you aren't left sort of having no guidance about this. That's not proper. It will not make for an effective process, and it will create liability problems for you as the practitioner. You don't want to do that. So, it is highly recommended that the parenting coordinator not commence the process unless they have a court order or a consent agreement. Consent agreements have different names depending on the jurisdiction, the area. In North America, this is United States, Canada, they're most often called court orders or consent agreements. They're two documents. One is a court order, and the other is what we would call a professional services agreement, okay, or a contract. Yes, okay, great, okay. So the guidelines recommend you do not start your process until you have your signed court order from the judge and your consent agreement or your contract, because this will clarify the scope of authority, the provisions for confidentiality, your obligations to the parties, fees, the monies that gets paid. All of that should be very clear in the order from the judge and in your contract between the parties. There is recommended language now that's been spelled out in the guidelines for the order from the judge. It is recommended that a specified term of service, meaning how long do you work, be clarified from the beginning. Most often, the initial term, the amount of time, is 2 years. That is the most common. Why? Based on social science. We know it takes families about 2 years to be able to stabilize after they've gone through a very conflictual divorce. There's lots of instability between the parents, with the children. Sometimes they have to make moves, they have a new job, or the children have to change schools, so many changes. So we know this is so even for families who are not in high conflict. So that's why if you have a shorter term, shorter amount of time, many families you will not be able to be successful with them. You need enough time to help teach them the skills, help them practice the skills, enact the skills, help them, support them, guide them, coach them, and then finish up your work.
Scusate, dobbiamo solo portare pazienza per qualche minuto e finiranno. Sono andata a chiedere. Sorry.
They're going to be banging all day?
No. Just 5 minutes, they told me.
Okay. All right.
Sorry.
That's all right. I can talk. Okay. If you can hear, I can talk.
Un'ottima mediazione.
No, scusate, ma è da stamattina perché siamo arrivati e avevano il martello.
Okay. So the language that is recommended for the order from the judge is to spell out the definition, the purpose, what your authority is, the access to information. So this is an important component in the language. Do you have the right to have access to a parent's privileged psychology records, for example? Do you have a right to records for the child's therapist? Do you have a right for access to school information, employment information about a parent? This needs to be specified in the court's order. In most jurisdictions, the parenting coordinator has access to all privileged and confidential records by order of the judge. You may not need all of that information, but it is important for you to have the right to have access to it in case you do need it. More often than not, you will need access to mental health records, medical records, school records. Those are common. So that needs to be clear from the beginning so that you don't have to go back to the court to try to get another order that's there. If you are to be authorized to make binding, substantive decisions, big decisions, then that procedure for making those decisions should be in that court order as well. Another element is whether you are expected to report to the court. Are you to let the court know, the judge know, how the family is progressing or not? That varies. Whether the judge will be reviewing the progress, and if so, on what time schedule will they be reviewing the process. Certainly fees and costs, how much you charge, when they have to pay you, what happens if they don't pay you. These are areas that can be problematic if it's not very, very clear in the beginning. If they are unhappy with you, they want to file a grievance against you, report you to your licensing, your oversight board. How is that to be handled? That should be clarified in these beginning documents. So the order of the court and your contract between the parties, between the parents, is what clarifies all of these elements that are important to specify in the beginning. If you don't specify them in the beginning, you will run into problems. Yes, yeah, it will be a real problem down the road. Okay, certainly you want to be in compliance with any local laws or rules or orders or other orders that are there. And your contract between the parties, between the parents, between the parents and you should parallel, should be consistent with the order from the judge. That's that. Roles and functions. So the parenting coordination process is now defined in terms of certain roles and certain functions. So the new guidelines differentiate between roles and functions. This did not happen in the original guidelines. This is new. I mentioned a few moments ago the multiple role of facilitative and mediative. But the functions within the process have been defined in terms of elements of the process in a certain sequence. An intake process, for example. Prior to the new guidelines, the intake process was not a separate function. It has now been clarified as a separate function. What is meant by that is to review the court file, in the history of a psychosocial report or a custody report, or if there's been police reports or a history of domestic violence or problems with the family, to clarify, review before you agree to proceed with the case. So it may have been a function that many parenting coordinators performed, but they didn't separate out what's called the intake process and then the assessment or appraisal. The reason for breaking it out, for separating it, is because the courts, the judge, most judges do not have a process for determining if parenting coordination is appropriate for a family or not. That is often left to the parenting coordinator to do. And some families were sent to parenting coordination and it was not the proper process for them. So the parenting coordinator needs to do an intake, an assessment, initial screening process to make a determination of, is this proper? Will this be helpful? Is it safe? Do I have the authority to do what I need to do? That's called now intake, or the intake or initial assessment screening process. The parenting coordinator has always had and continues to have a function of education, meaning educating parents about what their child's needs are, how to communicate effectively, how to resolve your disputes or conflicts without violence, to do so more effectively. So education is broadly following in the areas of expertise for the parenting coordinator. The parenting coordinator also has more of a case management coordination function. By virtue of definition, we are coordinators for parenting, not family coordinators. The case management component involves helping identify and organize the support team members, determining elements of the parenting plan or the guide that the families will need, any additional education or support services that the families or the children need. So there's a difference between case management and conflict management. Conflict management is a different function. So as you can see, whoops, sorry, can you go back? So the intake, this initial assessment, appraisal, intake screening process is the initial phase. It is during this time that you will have reviewed the court file and all of the other documents, custody report, psychosocial report, mental health records, relevant records, and then, can you advance, please? Can you advance, please? Yeah. Then you will have your contract and your court order to begin the other functions. Initially, the case management function is to help establish the communication between the parents, who's going to be on the support team, what kind of education is needed. If the children have any specific needs initially, that's the case management, the coordination function for the family. And then the family's level of conflict and type of conflict will determine the conflict management function. And that will differ based upon each individual family's dynamics and their needs. So these are the common roles and functions: communication protocol, decision-making, elements of the parenting plan, any written agreements between the parents. Informed consent is another guideline and function. One of the things we have learned from research is that parents often enter into the parenting coordination process and don't understand what it is. They may understand mediation, but they get it confused with family therapy, or they think it's something else. They don't know what it is. So when families are informed in the beginning, the parenting coordination is more successful, we have found. So it's an important part of the function of the parenting coordinator to inform the families. This is different than family mediation. This is different than family therapy. This is different than a custody evaluation. This is different than consulting with your attorney or your lawyer. This is not going to court. This is something different. And to explain what this process, PC, is, how it is different. That's an important part of the parenting coordination process. Some of that involves letting families know what power or rights they retain. They don't lose their rights coming into parenting coordination. They have a right to talk to their lawyer. They have a right to go back to court. They have a right to consult with someone else if they want to. It does not mean that the parenting coordinator doesn't have a lot of authority. Usually they do have a lot of authority over the families. But explaining this and explaining this in the beginning is very helpful to setting off the process on success. So many times the parenting coordinator in the beginning will need to review with the parents the judge's order and the consent agreement as a part of explaining that function, that authority, that role, what's confidential, what's not, what am I going to be doing, when am I going to be doing it, how am I going to be doing it. All of those things are the understanding of the role. Another area that is changing pretty dramatically is whether, and of considerable debate, has to do with whether and when children should be involved in the process. At the outset of parenting coordination, when it started 20-ish years ago, the thinking was that children should never be included. They should not be involved. That thinking has changed because we now have some research that shows that children can be helpful informants about their needs. And it is appropriate at times to involve the child in the process. The question becomes when, how, and how do you protect then the child if you involve them in this process? The goal, of course, is to not make their life more difficult, to put them more in the bind, the loyalty bind between their parents. They're already in a bind. Our goal is to shield, protect them. So involving the children in the process is becoming increasingly common, although it is not frequent. What I mean is that children are included, but they may not be included directly. So children may be included by an interview or getting information from the child's teacher or the child's therapist or someone who's the caregiver for the child, someone who knows a lot about the child may provide the parenting coordinator information so that the child doesn't have to be to attend the appointment. And then you have to decide, are the parents there? Are the parents not there? Do you tell the parents what the child said? Do you not tell the parents what the child said? How is the information to be used? So there's many questions to think about if you are going to involve the child. There is a journal, Family Court Review, that will be published next year with an article specifically about children in the parenting coordination process that may be quite helpful.